Hello and welcome to this Fox Nation special Trump on Trial live show. I'm your host, Greg Jarrett. Thanks for being with us, everybody. Well, the former president will be exiting the courthouse any moment now as I look at the television screen as his defense team rests its case today without calling Donald Trump to testify. That was a no-brainer. We knew that would happen. We said so. The jury is dismissed until, believe it or not, next Tuesday, so a week from today, when closing arguments are set to begin. So what can we expect as this trial enters the final phase? Here now to unpack it all, attorney and former Georgia Congressman Doug Collins is with us, federal defense attorney Ronald Chapman, and criminal defense attorney Dwane Cates. Gentlemen, thank you all for being with us. Dwane, let me start with you because I made no bones about it. I thought it was a bad idea to call Bob Costello to the witness stand on behalf of the defense. I felt there was too much of a risk. It might backfire. I think it did to some extent. Quite the ugly scene between the judge and Costello. Good move, bad move by the defense. What do you think?
I think it was a good move. I mean, you have Cohen, who's a known convicted liar, but even liars can tell the truth sometimes. So the jury's wondering, okay, is he telling us the truth now, when he tells us about what happened? And so you need some corroborating evidence around that to point to whether he's telling the truth now or not. And I think Bob Costello was great at saying he's not telling the truth now. He told me something totally opposite of that. And Bob Costello fighting with the judge, you never know how that's going to play with the jury. The jury may think that the judge was being unfair to him. I'm not a big fan of serial objections nonstop, but from what I understand, that's kind of what the prosecution did here during Costello's testimony. So I don't think it hurt him in the least, and I think that it gave them that maybe that little link they needed to say that he's lying now.
Well, you make a compelling argument. Ron, what do you think? Costello, good or bad for the defense?
I think overall probably a net positive. From my understanding, and I listened to Trey Gowdy earlier, he calmed down a little bit more today. Trey was in the courtroom and certainly is the type of person who can analyze a witness quite well in all of his years of prosecution experience. But here's the thing. Defense attorneys often shy away from calling witnesses. That's something I've disagreed with. In all of the trials that I've been involved in and the acquittals that I've had, the number one thing is I put as many witnesses on the stand as I can to get the truth out. And the truth is, so much was going on around this time period, and so many people were doing things on behalf of the Trump organization that it was really hard to keep everything straight, and you couldn't necessarily understand what everybody was doing. The messiness of the Cohen-Costello situation actually cuts towards Trump in his favor because it does show that he wasn't necessarily intricately involved in all of the operations. And of course, that's reasonable doubt, and that's an acquittal.
Doug, you were a very fine attorney before you made the mistake and went into politics. But look, we all sin, so I'm not going to hold it against you. What's your feeling about Bob Costello taking the witness stand?
I agree with the other two. I think it was probably a positive. He at least provided something of a mix between what they've been hearing. The problem I'm having, though, is with this judge, and then with as was said earlier, the serial objections from the prosecution. They just come across as that we don't want you to hear certain things. It's really, in looking at and parsing the transcripts and looking at things coming out here, it's almost as if the judge in the case says, I'm the sole arbiter of anything of what you will hear. And that's a part as a defense attorney as well. You sit there and you say, look, I have a right to present my case. Justice is supposed to be blind to either favoring the prosecution or favoring the defense. But what you've done is you set it up to say, look, we're not going to allow you to bring in the answers that we've actually been charged with. So I think as we've talked about this over the last couple of weeks, Greg, the issue here to me is how is the defense trying to work from a position in which they're being put in some ways in shackles by a judge who won't let them really have their own defense. And I think that was what caused this Costello to have to come, because they wouldn't let the FEC commissioner come, which I think was a big mistake, and possibly, even an appealable kind of offense, because it looks like where you're taking here is you're limiting the defense's capability of actually answering the charges or vagary of the charges given to them.
Dwane, Doug brings up a good point, the bias of the judge, which I thought throughout the trial was severe. He wore it on his sleeve. And it wasn't just that he always seemed to sustain prosecution objections and overrule defense objections, but the latitude that he allowed prosecution witnesses, Michael Cohen, Stormy Daniels, they were allowed to say anything they wanted, gratuitous details, particularly Stormy about her alleged sexual encounter with Donald Trump, prejudicial information that no other judge, I think, would ever allow. Then when it came time for the defense to put their sole witness on the stand, Bob Costello, he basically, stuffed a sock in his mouth and limited what he could say. To me, it was just conspicuous pro-prosecution prejudice by the judge. What say you?
Well, and I think so. And what I'm hoping is that the jury sees that. And even though they're probably not big Donald Trump supporters, I hope that they see that what's happening to him is not fair. I mean, to me, it looks like it's not fair. To a lot of people that I talk to, it looks like it's not fair. Even some liberals think it's not fair. So I'm hoping that the jurors sitting there will pick up on the fact that that's going on. And then, and again, the objections are, you don't want to object too much. It makes you look like you're hiding something.
Right. Ron, Mershon allowed Cohen to testify almost as an expert about campaign finance laws and saying, oh, yes, this violated the law. Cohen's not an expert. First of all, he was a terrible lawyer. Even basic stuff he seemed to bungle. And yet the judge allowed him to be an expert on campaign finance, but when it came time for the defense to call an esteemed expert, Bradley Smith, former chairman of the Federal Election Commission, to say, look, this is why these payments in the non-disclosure agreement doesn't qualify as a campaign contribution, and therefore it violates no law. The judge really wouldn't let him say that. And so in the end, the defense didn't call Smith. They were precluded by the judge. I think it's another instance of unfairness. Do you think so?
Well, yeah, it certainly is concerning, but always a difficult decision for a judge. And let me break this down a bit. So we see this a lot in tax cases and healthcare cases where we have a very complex regulatory scheme that needs to be analyzed by a jury. Typically, juries should only hear instructions about the law from the judge. But occasionally experts are necessary to explain complex regulations. That's exactly what was necessary here. These regulations are so intricate and complex, they really require something more than just mention of the law during the jury instructions. But the judge said, I will instruct on the law. Then we expect him during the charge conference, which happened today, to actually provide some instruction on federal election law. He refused to do that just today. So that 1-2 punch really starts to look like an appealable decision. In fact, Donald Trump's best appealable decision. Jury instructions are some of the most reversed types of cases. And I think that's exactly where his defense team will go with their appeal. It does look like bias. It looks like poor decision making, and it looks reversible to me.
Oh, yeah. But, it'll be too late. I mean, there's no way you can get a conviction reversed in time for the election. The prosecutor knows that, so he doesn't care about reversible error. I don't think the judge cares about reversible error because he's made so many of them. His entire case is blanketed with reversible error. Doug, what do you think about the motive behind this prosecution and the prejudice of the judge who should have absolutely, under the rules of judicial conduct, disqualified himself.
I think that's going to become the historical marker of this. Look, we all write sort of the history in the making, and that's typically, needs a lot of step back subjectivity. But in the history of this, people look back on this, they're going to, 5-10 years from now, they're going to say, really, this happened? And they're going to look at it in a sense of, how did this judge allow this to go this far? I think that's the concern that most of us have. I had a post the other day, and I made clear, I'm not sure where the New York judiciary is at this point. I mean, when you have a judge that allows a fraud case that was nowhere close to fraud, and then you have this judge who is actually looking at it from a perspective of how do you get a case that is supposed to tie to a federal law that it was outdated, FEC didn't even follow up. Again, and it starts all the way back at jury selection. So, yeah, I think this is going to be a real problem for him. But you hit it right, Greg, and let's just be honest here. Instead of legally analyzing it, they wanted a conviction, and the conviction is all they care about, because the reversal will come on page 45 of the New York Times. This will come on the front page of the New York Times.
Yeah, I think you're absolutely right. The other thing I can't understand is why this judge would allow his courtroom, Dwane, to be misused and exploited for a case brought by a local prosecutor who has no authority to enforce federal law, to wit, federal campaign finance violations. I think the Department of Justice, were it under a different administration, would have filed a flurry of motions before the court saying, this is the improper venue, you can't allow this. But of course, Merrick Garland's been cheering this on, so the DOJ is not going to do that. But I just find it to be turning the law on its head by allowing somebody like Bragg to bring a federal case.
Yeah, and the prosecutor that tried this case, came from the Department of Justice, took a huge cut in prestige to become a local prosecutor to do this case. So this is basically being prosecuted by the Department of Justice, and the judge allowed his courtroom the forum to do this, and he's made bad ruling after bad ruling after bad ruling all the way down. And again, I don't know if there was some sort of interlocutory appeal that could have been taken about making the judge recuse himself, because I never thought it was really fair when you ask a judge to recuse themselves. The judge is the one that gets to decide whether they're recused or not. And I think there should have been maybe an interlocutory appeal taken to see what the Court of Appeals thought of that.
Ron, here we are at the end of the case. The prosecution rested, the defense rested. They're arguing over jury instructions right now. A week from today, they'll be closing arguments. And guess what? We still don't know what the underlying crime is, this so-called mysterious crime. I mean, this was always a preposterous legal theory. Expired misdemeanors are elevated into a felony because the false business records were done to conceal another crime, which even to today, they have yet to identify. And today, while they were arguing jury instructions, they said, well, we want to argue various theories of different underlying crimes. How in the world can any competent, fair, objective, neutral judge allow that to happen? Isn't that an egregious violation of the defendant's Sixth Amendment right? He is entitled to specifically know the accusations against him, and yet the mysterious crime is still mysterious.
Absolutely. I couldn't agree more. Here's the strange thing. We have Alvin Bragg offer this memo early on in the prosecution, very strange move, that laid out potential theories. We then heard the opening statement, didn't really see dots connected, scattershot with respect to the theories. Then we hope that by the time we get to closing arguments and jury instructions, they've picked a theory, but no, they won't stake a claim. And we have the judge in this case rejecting the idea of a double intent requirement. We know from hearing it a bunch during this case that New York law requires that for this to be a felony, you have to show that there was intent to commit a felony. in covering up these business records? Well, the judge in this case has said you only need to prove intent once, and that is intent to falsify the business records, changing the nature of the statute and allowing the jury in this case to convict potentially on what is really a misdemeanor violation. That is a huge concern, and again, a massive issue in the case. And really, Alvin Bragg's team gets to stand up and say, we believe he violated the law because we believe he violated the law, and he did that by doing something that we believe violated the law. And that's it. That's not how America should be. That's not what's in the Constitution. That's not justice. And it shows that this dog and pony show was really just to bind up a presidential candidate to prevent him from running for office.
Hey, Greg.
Doug, go ahead.
Yeah, no, I just want to jump on what Ron said there because I think it's important to note here because they've never really developed the theory of the case. We've done this show, and several of us have for the last few weeks. Nailing out that the prosecution's job is to go point by point by point. Here's the elements. Here's how we prove the case. Well, it's pretty easy when a judge allows you. Basically, it's like you're always going to hit the bullseye if you have no target you're shooting at. And I think that's what's happened here. They've allowed the prosecution just to shoot an arrow, and if it hits the wall, they'll go and draw the circle around the arrow. The other part here is this case should have ended early on in Michael Cohen's testimony when he was asked and discussed, and he made the comment, I was on legal retainer doing legal work for Donald Trump. At that point, the judge, if he was anywhere halfway not biased or competent, would have said, sent the jury out, and basically looked at the Trump defense team and says, I'm waiting for a motion here because he just destroyed the case right here. The whole case was this was not legal work, and he just admitted it was legal work. So, to jump into that real quick, Greg, I didn't want to interrupt your question, but I think what Ron said was very important.
Yeah, no, and Doug, let me stick with you for a moment. I'm so glad you brought that up, the issue about falsifying business records. They weren't falsified at all. First of all, the entries, legal expense, were made on an outdated computer program with a limited number of entries, and it was entered into the computer ledger by an accountant with the approval of the comptroller. And they both testified, we're the ones who put it in there, not Donald Trump. He didn't tell us to. He didn't even know about it. We put it in there because in our judgment, we're paying our lawyer, Michael Cohen. That's a legal expense. So if you can convince the jurors during closing arguments next Tuesday that that is the case, doesn't that wipe out everything? Game over, prosecutors lose?
Yes, I think almost their closing could be simply a regurgitation of the opening from the prosecutors and say, here's what they said, they failed. Here's what they said, they failed. Here's what they said, they failed. Oh, and by the way, their own star witness said it was a legal expense. Ladies and gentlemen of the jury, I'm not sure exactly what you've been listening to for the last few weeks, but when you heard that, that should have been the end of the case, and this is where we need to go because really – the accounting part here, it goes to intent that was spoke of earlier. It goes to what was actually done earlier. But the real case here was the simple fact that it was a legal expense. I don't know how else, when a lawyer tells you I was doing legal work, how else would you classify it?
Yeah, I mean, it's the equivalent of pulling the rug out from underneath the prosecutors. Here's Donald Trump walking to the cameras. Let's listen.
Jonathan Turley just came out with a statement that he thinks that this case is collapsing of its own weight. This case is a disgrace to our country, to the state of New York. Never seen anything like it. Stephen Calabresi, it's an outrage that the district attorney brought this case and that the judge did not declare it a mistrial. Very highly respected. Stephen Calabresi. He says an outrage that the district attorney brought this case and the judge did not declare a mistrial, and everybody's saying it in one form or another. Andy McCarthy, what they have, this kind of a case, is that the federal prosecutors at my old office, the Southern District of New York, wouldn't take it in the first place. They would not take it. The Southern District turned down this case. And the case that Cy Vance looked at and wouldn't take it, and the case that Bragg himself looked at in 2022 and shut it down. And this is what we've been wasting all this time on. Alan Dershowitz, I've observed and participated in trials throughout the world. I have seen justice and injustice in China, Russia, Ukraine, England, France, Italy, Israel, as well as in nearly 40 or 50 states. But in my 60 years as a lawyer and law professor, I have never seen a spectacle such as the one I observed sitting in the front row of the courthouse. I've never seen anything like it. He's been a great lawyer, a great legal scholar for years. He's never seen anything like it. It's all politics, said Leo Terrell. If anyone tells you otherwise, they're not a lawyer. Let me just tell you that the White House is the person or the group, whatever. They're the one trying this case. You heard who was doing all the talking. Representative from the White House. Just recently. This is all about Biden. Can't campaign, so he's trying to injure his opponent. They're trying to hurt the opponent because they can't win it fair and square. It's lawfare. There are a lot of terms for it. It's a third world country way of campaigning. Such a disgrace. So sad to see what's happened to our country. Our country's going to hell under Biden. But look at the person. Why don't you look at the person that argued their case, almost the entire case? Look at the person. Where did he come from? Unbelievable. He came from Biden. And I don't know if it's Biden because I don't think Biden has any idea what the hell's happening. But it's from the fascists that circle in the Oval Office. They circle the Resolute desk, the beautiful Resolute desk that's being stinked up. Byron York, campaign finance law is extraordinarily complicated. Back in 2013, in an oral argument, Supreme Court Justice Antonin Scalia said, this campaign and finance law is so intricate that I can't figure it out. And what he's referring to is the fact that we had a legal expert, the #1 expert on campaign finance law, who wasn't allowed to participate. He wasn't allowed to participate. They said he can't be a witness unless you want to just talk about what's the definition of the law. You couldn't talk to him about anything else. Greg Jarrett, this trial is now officially a sad and pathetic joke. It's a crime. Mershon and Bragg are the head clowns. It should be patently obvious to all that the leading Republican candidate for president is on trial, not for what he has done, but for who he is. Trump is the potential nemesis of the Democrats. By the way, I've just gotten out of court. I haven't even seen this until I'm reading it to you now for the first time. I haven't even looked it over. I'm just giving it to you because everybody says the same thing. Bragg loathes him. Oh, I'm so surprised. And so does Mershon, loathes me. The judge hates Donald Trump. Just take a look. Take a look at him. Take a look at where he comes from. He can't stand Donald Trump. He's doing everything in his power. I understand that I don't even have any reliance on counsel. I can't rely on this guy was counsel. I don't have any reliance on counsel. I might be the only one ever that doesn't have reliance on counsel. We have so many bad decisions. This guy, everything we ask for, we get nothing. So he says, Biden despises Trump. Bragg loves him. And so does Mershon, but it's all the same group, who's taken it upon himself to serve up as the co-prosecutor in the case. This is from the great Greg Jarrett, very talented guy. It's a persecution, not a prosecution of any legitimacy. Bragg has abused his position of power and spent tens of millions of dollars of taxpayer dollars. Do you see how many people from his office over there, while people are being mugged and killed outside? Never saw anything like it in my life. Nobody has. Bragg has abused his position of power and spent tens of millions of dollars to denigrate an electoral enemy. I'm the enemy, but to denigrate an electoral enemy to benefit his opponent, President Joe Biden, commonly known as Crooked Joe. The DA falsely asserts that Trump unlawfully tried to influence the 2016 election, but it is Bragg who is guilty of interfering in the 2024 election. They're doing it in 2024 just like they did in 2020. Can you imagine, with all of the wrongdoing that we found and that you know existed, they're coming after me for election interference? That's the classic of all. That's the classic of all. Tom Fitton, the sham Democrat Party prosecution of Trump may be collapsing in New York, but the process is the punishment as Trump is held a political hostage for the weeks in this kangaroo court proceeding in the middle of a presidential election. The show trial has already compromised the election. They're already cheating on the election with this, and you don't know what's happening because the judge is so biased, so corrupt. He's so corrupt. And he's so conflicted that you never know how these things. I'd rather have honest judges. But a corrupt judge will far surpass a great case for us. When you have a corrupt judge, lots of bad things happen. Katie Cherowski, this is such an embarrassment of a showing of prosecution that I imagine the judge wouldn't grant the motion to dismiss the case. You can't imagine it. There has been no evidence. There's no evidence, and there's no crime. There's no crime. Everybody says there's no crime. Where's the crime? And these are all your top legal scholars. Doug Schoen and Carly Cooperman are finding, and he's a very big Democrat, I don't even know what he's going to say. I'm reading it now for the first time. Are finding that large pluralities of outright majorities of Americans perceive these indictments as politically motivated should be a warning sign to the Democrats. These are Democrats that wrote it, Doug Schoen. John Yoo, I'm not sure there isn't going to be backfire on the prosecution having a judge who's so aggressively on their side. He is so aggressively on their side, but he has to be. He has to be. He has to report. He has to be. Joe Concha, good guy, starting to think this whole Lawfare strategy wasn't a good strategy at all and is having the inverse effect that Democrats had hoped for. So the Democrats thought they were going to take me out with the Lawfare. And it's so bad that at least I have a voice where I can talk to you, the press. In many cases, the fake news, but even the fake news has to cover it. Bill O'Reilly, the state of New York, and the image of the state of New York is in place of freedom and fairness is in tatters. Mike Davis, this is obviously a political hit against Trump, as well as a blatant election interference, and is totally unconstitutional. The American people see this trial as a complete sham. Well, so far they have, because I'm leading crooked Joe Biden by a lot. They thought they could take me out with this. And don't forget, I have like 8 of them going. This is one. I have others going too, and we're doing very well on them. So, and this goes on and on. There's not one person, legal scholar, that think this is of merit. Now, I haven't reviewed everything, but I can see none. The ones when you hear Mark Levin, likewise, a phenomenal statement. A sham, a disgrace to America. All great legal scholars. Andy McCarthy, many, many documents, many papers written by Andy McCarthy, somebody I respect. But he's tough and he's legit. And he says, this is terrible what's going on. It's terrible what's happening to our country. Mark Thiessen wrote likewise. Terrible what's happening to our country. It's an embarrassment and it's so sad. And I appreciate you listening. But I just watched something go in there. And you have to look at the man that did all the talking. Who's representing? He wasn't in the DA's office. He wasn't in there. He came in for one reason. And where did he come from? He came from Washington, D.C., the White House and the DOJ. And he argued the case. That means it's Biden. That means it's election interference by Sleepy Joe, our dumb as a rock president, who's destroying our country with the borders and destroying our country with the worst economy
The defendant in this case, the former president of the United States, leading candidate for the presidency in 2024. November is the election. Reciting legal experts and their opinions. He apparently reads my daily columns. The point I tried to make, which he repeated, is that Trump is not on trial for anything he did, but for who he is. Let's go around the horn and get final thoughts from our distinguished panel. Doug Collins, give us your final thoughts.
I think he's expressing the frustration that all of us are watching this from a legal perspective, from just a political perspective. This is a sham job. It's a political persecution. And again, the New York judiciary has to be ashamed of itself at this point. I mean, this is I cannot imagine trying to be a defense attorney or even, frankly, even being a honest prosecutor in this jurisdiction with everything going on. And this is what we're spending time on. And the other judges, I mean, this is it's just hard for me to believe, as much as they hate Donald Trump apparently, that they will not even see how this is destroying people's opinion of the law, which is the very lifeblood that we have as our country, and that position of prosecutor and defense attorney. And you have prosecutors abusing it like this, and a judge willingly letting it go on. It's just terrible.
Yeah. Ron Chapman, your final thoughts.
Yeah, I think my final thoughts relate to closing this case out. Shocking that we have to wait more time than jury selection took for the closings to take place in this case, but here we are. The message is that this case needs to be about something other than Donald Trump. This case needs to be about justice. It needs to be about the political will of those folks in the prosecutor's office really trying to impact the election here. But in closing, you really need to send a strong message that convicting Donald Trump is a vote against justice in that area. It's a vote against holding or it's a vote for holding up the courts and preventing justice from being done in the murders and robberies and rapes that might have occurred in that area. And really, it would send a strong message that this sort of lawfare, as people have been calling it lately, is tolerated and tax dollars can be used in furtherance of it. And I hope those dots are connected, because I think this jury really needs to understand that we are left with the decisions that we make here in the future. And we have to live in a society that was shaped by those decisions, and they better make good decisions, and they have the power to do that. And I think that needs to be the message that's delivered in closing.
Very well said. Dwane Cates, your final thoughts.
Thanks. I always, in my closing arguments, I always talk to the jury and thank them for their service and remind them that our founding fathers were so smart that they didn't want to leave the decision of guilt or innocence up to the government, that they took that away from the government and they hand it to citizens, and that they have an obligation as a citizen, okay, to do what's right, okay? And in this case, if they do what's right, they got to find Donald Trump not guilty.
Well, my final thoughts are, I think this trial is now a sad and pathetic joke. It's a circus. Alvin Bragg and the judge, Juan Marchand, are the head clowns. And, it's a sad day for American justice. Only the jury can put a halt to this miscarriage of justice. The question is, will they? Doug, Ron, Dwane, thank you for joining us today. Appreciate it. And thank you all for watching this Fox Nation special Trump on Trial live show. We'll be back next week after closing arguments. I'm Greg Jarrett. We'll see you next time.